Hello and welcome back to Let's Talk Title with Emerald Coast Title Services. I'm president of ECTS and host, Dion Moniz.
And I'm Ashley Bowen. I'm a licensed title agent and co-host.
So today we're going to talk about types of tenancies, and that's Tenancies. Sounds like there's a T in
So
there.
these are the different ways you can take title to the property.
Yes, exactly.
And that is determined on the warranty deed that is recorded at closing.
Right.
So you better tell us before closing how you want to take title.
Well, we're going to ask. But yes, it's something to think about when you go to buy a property is how you want to hold title to that property. So there's two types of tenancies. Ashley, why don't you tell us about those?
Okay, so there's tenants in severalty, and then there's joint tenants.
Or co-tenants. Co-tenancies.
Co-tenancies.
Yeah.
Okay. So there's tenants in severalty is a person who holds real title alone, which means that his or her interests are severed from all others. So that's why it's tenants in severalty.
Yep.
And then the joint tenants or the co-tenancy is whenever you own the property with someone else.
Right.
And then there's different types of co-tenancies or joint tenants. What if it's like, if it's just an LLC or just a trust or just an entity, is that a tenant? That is still tenants in severalty because it's one.
Well, yes, it's owned by an entity. So yeah.
But in this case, we're talking about pretty much individual, the way the individuals can hold
this
title.
is regarding individual tenancies. If you own property through an entity, then obviously the operating agreement or the governing document for the entity then controls when they can sell the property, etc. But with regards to individual tenancies, that's what we're going to get into.
Okay.
And so there's three types of co-tenancies. Joint tenants is actually one of them, but there's also tenants in common and then tenants by the entireties. And so we'll start with tenants in common, which is the default, which is if you say John Smith and Jane Doe, and that's all you say, then it's presumed tenants in common. And so tell them what tenants in common means,
Well,
Ashley.
So I assume that if it just says Tom Smith and Jane Doe, that it is going to tell us to automatically assume a 50-50% ownership if it's not specified. Each tenant holds their own separate interest in the property. And so John Smith can sell his interest, his 50% interest to someone else, and Jane Doe still has her 50%.
Yes, the interests are separate for each co-tenant. And so if it's tenants in common, one of them can sell their half to someone else without the other tenants or co-tenants' approval, which is interesting.
If one of the co-tenant or the tenants in common were to pass away, then their part of that property will go to their heirs or however their estate is.
Yeah, there's no right of survivorship.
Okay.
And so, and again, so it's completely separate interest in the property. And so any co-tenant has the right to sell, convey, mortgage, or transfer his or her interest without the consent of the others.
Okay, so they could even take a mortgage out on just their 50% and the other party wouldn't have to.
I mean, technically, yes. I don't know what bank would do that, because they're going to want a mortgage against all of it in the case they have to foreclose. But yeah, I mean, if they just have a mortgage against 50%, they can foreclose that co-tenant's 50% interest and then, turn around and it be sold on the foreclosure steps or the courthouse steps foreclosure.
All right.
Okay, so that's the default tenants in common. The next one is joint tenants, which is when the co-tenants actually have an undivided interest. Actually, let's back up. So actually what happens, you mentioned earlier under tenants in common, if there's two names on the deed, it's presumed 50-50. Well, what if there's three or four names on the deed?
Well, then we're going to have to assume an equal ownership share unless it's specified.
Yeah, so you can actually specify different percentages. It doesn't have to be equal shares.
It could be 50%, 25%, and 25%, but you have to tell us.
Right, because that has to be specified on the deed. If it's not specified,
then we're going to assume 1/3, 1/3, 1/3.
Exactly, right. So be thinking of that as well, because we've certainly had situations where one person owned a larger share than the other co-tenant. And so it can be split up any way you want. You just have to let us know. All right. So Joint tenants is, again, where you have an undivided interest. And so it's called unities of title. And it's basically 4 different requirements. So all joint tenants must hold an undivided right to possession, hold equal ownership interests, acquire their interest at the same time, and acquire their interest under the same instrument from the same source. So,
Okay, so like they have to have taken title on the same deed, and they all have to have the same amount of ownership interest. You can't have a 1585%
correct.
on one of these
Yep.
joint tenants.
And one joint tenant can't sell or do anything with his or her interest
without the other.
Yeah.
It's
They
like
either
a
all
married
agree or
couple.
they don't. Yeah.
It's
exactly.
kind of like a married couple without being a married couple.
Yeah.
In this case.
Right. Yeah. They're all bound together essentially.
Okay.
So joint tenants without additional language that we're going to get into also does not have a right of survivorship. And so it creates a little more of a problem if one joint tenant dies, how that undivided interest is handled, but ultimately it passes through the estate plan of that joint tenant. And so that's a probate issue, obviously. But typically, if you are joint tenants, you want to have rights of survivorship. It's, all that requires is for us to put on the deed John Doe and Jane Smith as joint tenants with right of survivorship.
And then it's so easy if when someone passes, the handling of the property, because then you just have to record a death certificate for the most part.
Yep.
And then the title's automatically conveyed to the surviving owner.
Right, exactly. You don't have to worry about probate. You don't have to worry about a will. It automatically, so if there's 2 owners, one of the, or 2 joint tenants with right of survivorship, one joint tenant dies, that 50% automatically passes to the surviving joint tenant with nothing else being done other than recording the death certificate.
And in this case, in the previous case, in tenants in common, if someone were to pass away, then their heirs would get the property. However, their estate is probated and they can do whatever they want with that 50% of the property. But in joint tenants, because they have to take title together, and then do they also have to relinquish title together?
Yeah, so ultimately, actually, great point. So in the tenants in common situation, if the interest passes down through the will, the heir can do whatever they want with that interest. They can sell it, whatever. Joint tenants, they just become an owner with the other joint tenants, and they're bound to the rest of them.
Until everybody wants to sell.
Yeah, they step into the shoes of the deceased joint tenant, and they can't do anything with their interest unless all joint tenants agree.
Okay.
Yeah. So, nice. And like I said, we recommend if you're going to hold it as joint tenants, you might as well have it with rights of survivorship. Otherwise, do tenants in common, because then there's more flexibility to do what you want with that interest in the property.
Okay.
All right.
And now so you said there's 3 types. We've got tenants in common, joint tenants, and now
tenancy by the entireties.
Okay.
Which is basically a married couple. And so the key language on the deed there, as long as you say John Smith and Jane Smith as husband and wife, or a married couple, then that automatically triggers a tenants by the entireties protection or category for that ownership. And it's basically like joint tenants. The husband and wife are considered one owner for legal purposes. So it's an undivided interest. Again, they can't do anything with it's not a separate interest that can be disposed of or anything else. So it's just like joint tenants in that situation, but it automatically comes with right of survivorship, which the joint tenants doesn't unless you specify the survivorship language. So if it's tenancy by the entireties, automatically rights of survivorship. So one spouse dies, the deceased spouse interest automatically passes to the surviving spouse. No will needed, no probate, etc. So it's nice and clean.
And so, but there is a benefit. One of the benefits of tenancy by the entirety is that the judgments against one spouse can attach to property that is owned as tenancy by the entirety.
Yep, that's the other big benefit you get with tenants by the entireties is you get creditor protection automatically. So the only way a creditor can get to the property of the married couple is if the judgment is against both spouses. Now, homestead, we won't get into that because that's a whole different situation, but because that carries separate protections under the Florida Constitution. But yes, in general, if a husband and wife own a piece of investment property and it's got the husband and wife language on there, so it's tenants by the entireties, then if the judgment is not against both spouses, the judgment does not attach to that property whatsoever.
So that's a benefit, but a problem with tenancy by the entirety is that when you own property with your spouse as tenants by the entirety, then you cannot alienate or encumber that property without your spouse. So
That's
then
right.
you're stuck with them. So you can't sell that property without your spouse's signature, and you can't get a mortgage on that property without your spouse's signature.
Yeah, which is like joint tenants, but yeah.
Even if, I probably at least twice a year I get a call from there's some guy who wants to refinance his house, and his wife that he's been separated from for 20 years, they're not married, but they're still married. They don't want her to have to sign, and I'm sorry, sir, she's going to have to sign. We're going to have to go find her, and she's going to have to sign.
Right. Where you get the situation where the spouses are estranged pending divorce, but the divorce isn't final. One spouse is trying to sell the property, maybe without the other spouse's consent or knowledge,
or wanting to buy a property so they can move out, but they have to sign the darn thing.
So you can have, so if it's John Smith and Jane Smith, nothing else on there. If it doesn't say husband and wife, then automatically it defaults to
a joint tenants, right?
Tenants in common.
I was wrong.
Yeah, because
that's the default.
In order to invoke joint tenants category, you have to say John Smith and Jane Smith as joint tenants, or as joint tenants with right of survivorship. So again, if there's nothing behind the names on the deed, then it defaults to tenants in common.
Okay.
Yep.
But I hope that we never see a deed that says John Smith and Jane Smith and nothing else.
Right.
It's really important that you put everybody's marital status on there.
And that's something we always ask at the very beginning. We send our form out asking you how you want to take title.
And that's the reason that we ask the marital status, is because if you take title as a married man, then, and it is your homestead, right?
Spousal interest.
Then
I was just going to get into that.
Spousal interest.
Right.
And so whenever you go to sell it, then, if it was your homestead and you were a married man, then we need your wife to sign it.
Yep. Absolutely. So under the Florida Constitution, or the Florida statute, there's what's called the spousal interest in the homestead. So if husband and wife are living there, even if the wife isn't necessarily on the deed, she still has a statutory interest in that property. And so banks, primarily, if it's going to be a homestead property, they will require the spouse, even if not on the deed, to be on the mortgage, where that spouse agrees that if the other spouse defaults under the promissory note, then both spouses consent to foreclosure of the property. And so otherwise you can't sever that spousal interest. That's protected under Florida law. So yeah, it becomes a problem if it's homestead and both spouses are on the deed. I mean, not a big problem, but that's why you're going to see banks require both to be on the mortgage, even if they're not both on the deed.
And there's no, in the state of Florida, there's not a waiver of that spousal interest. I've had a lot of lenders ask me, can't we just sign a waiver so she doesn't have to sign?
Nope.
I didn't think so.
Nope. Yeah. And so, and a lot of, again, if they're in the middle of a divorce, I've had to tell one spouse that, sorry, your wife does have half an interest in that property, even though she's not on the deed, because Florida law says so. So anyway, that's a whole different topic. Not talking about divorces today.
Okay, so we've got two types of tenancy, either tenants by severalty, which is where you're severed from all others, you own it all by yourself. And then there's co-tenancies. And then within co-tenancies, we've got the three types: tenants in common, which is our default, the joint tenants, and the tenants by entireties.
Yep, exactly.
And the tenants by the entireties is the strongest.
Yes. Yep, that has the most benefits. So I think we've covered it all as far as types of tenancies. So if you have any questions, feel free to send us an email or post it to one of our podcast pages, whether you're watching or listening. we hope you are watching or listening, or subscribe to our YouTube channel, or follow us on any of the other podcast channels. Feel free to look us up on social, follow us there. And in the meantime, I guess we'll say goodbye for now. Bye-bye.